I think we have 4 agenda items. Good evening, everybody. I believe we are ready to start today's DRC meeting. Correct, Camelia?
Yes.
Thank you so much. Welcome everyone to the San Marino Design Review Committee hearing on July 6, 2022. The City of San Marino appreciate your attendance. Citizens' interest provides the Design Review Committee with valuable information regarding issues of the community. Let's start with a call to order.
Yes. And for the sake of the meeting minutes, I'm just stating for the record that the meeting started at 6:02 p.m. And for roll call, Chair Wong.
Present.
Vice Chair Lakin.
Present.
Committee Member Chang.
Here.
Committee Member McKay.
Present.
Alternate Committee Member Rick Chow.
Present.
And alternate Committee Member Tony Chow.
Present.
And we have an absence for Committee Member Batanish.
Great, thank you. We have the quorum, so we are good to go. So let's begin with a flag salute. Let's stand on your own. I pledge allegiance to the flag of the United States of America and to the
Which stands
One nation.
one nation under God, indivisible, with
Indivisible,
liberty and
liberty and
justice
justice for all.
for all.
Thank you very much. All right, so the agenda is posted 72 hours prior to the meeting at the following locations: San Marino City Hall, San Marino Public Library, San Marino Recreation Department, as well as the San Marino City official website. Each committee member has received plans and has reviewed every item on the agenda and visited each site. The general order for hearing each case will be as follows. The committee will ask staff any questions they may have. The chair will then ask the applicant or the applicant's representative to comment on the proposal. The hearing will then be open to the public and the chair will ask for comments for, against, or about the project. Staff will provide a brief explanation on the public hearing process for the meeting later. In all cases, please come forward and give your name and address. At the conclusion of the public hearing, the applicant will have a chance to respond and no further comments from the public will be accepted. The chair will then ask for comments from each of the committee members. If there is no motion for approval or denial, the DRC has the option of continuing the application to a future meeting. In the event of a denial, it is hoped that the applicant will have heard comments during the public comment period and during deliberations that will be useful in resubmitting an application. It is important for the property owner to understand that once a project is approved by the DRC, the drawings become legal documents. If any changes are made to the project subsequent to approval without obtaining proper approval of those changes, then the property owner is in fact breaking the law. There is risk of having to change the project back to the originally approved design or paying a fine to the City of San Marino equal to the greater of 5% of the project valuation or $2,500, and then resubmitting the changes made to the project to the DRC. It is also important to understand that there is a 15-day appeal period after action has been taken for the applicant or any interested party to request a planning commission to review and act on the case. After all of the agenda items have been heard, 2 design review committee members will conduct the open forum. I think we are not doing that now because of the online meeting format. I'll now turn to staff for an explanation on how we will take public comments during the meeting. Camelia, please.
Yes. We will, for each item on the agenda, there will be a time for a public comment and we will accept comments in 3 ways. We will take in-person comments for each item. via an email sent to planning@cityofsanmarino.org. The email address is also found on the agenda. These will then be read into the record. We must receive these emails before the public comment period for the particular item ends. The comments may be summarized if necessary to limit to under 3 minutes. The second option we would then ask for comments through our Zoom participants. When we ask for public comments via Zoom, there are 2 ways you can let us know if you would like to speak. The first, you can use the raised hand feature, which is a button that is found by clicking on the participants and then clicking on the raised hand on the bottom right-hand side of the screen. Please do not use this feature until we have asked for the public comment, or else we may not see it or know which item you're asking to speak on. As a second option, you can send a message using the chat box saying you would like to speak on this particular item. Comments will be accepted only until the end of the public comment period for that item.
Thank you. Thank you. So let's move to the first item of the day. Camille, could you help cite the case number and the details and provide the staff report, please?
Yes, so this is for item number 1 under the consent calendar, which is for the extension request for design review case number 19-91 for the address of 1270 Oxford Road. The applicant is requesting an extension of time as the previous 1-year approval from the design review committee has expired, as well as the director's authority under the emergency ordinance to approve a 90-day extension. And that has also since expired on May 31st, 2022. Therefore, the applicant is now asking for an extension. Staff recommends a 9-month extension, which would then lead the new expiration date to February 31st, 2023. In the attachments as part of the staff report, you have the plans that were previously approved by the DRC, the previous approval letter, which states the formal expiration date, and then thirdly, the applicant's request letter as to why they are requesting a time extension. I'm available to answer any questions, and the applicant is also online to answer any as well.
Thank you, staff. First, I'd like to see if there's any question from the committee to staff, please. Please feel free to raise your hand. I have one for staff. Is that the 9-month extension, is it a typical time period provided by the department, or is it something that is based on the current situation?
That's a good question. As I haven't been here very long, in researching other projects that have come across my desk that have been approved extensions, it's varied between 3 months to a year. You are allowed up to a year to extend up to. We are suggesting 9 months as the applicant is in its 2nd round of corrections with our building plan check. Potentially, I might need a 3rd round of corrections depending on what's submitted. And then after that, it would be routed to planning, where I myself would have to review the project for its completeness and comparing it to what the DRC previously approved. Given those timeframes, and not to come back to you to ask for further extension, staff is currently recommending 9 months. The DRC does have the authority to shorten that or extend it up to a year should you wish.
Thank you. Any other questions from the committee at this point?
Chair, I just want to make a comment. I think 9 months is a reasonable period if they are on plan check. And it will take usually about 3 months to get all those corrections clarified and then go back to planning. And that will allow them a little time to get started for the construction. So I think 9 months is a reasonable period to ask for extension.
Thank you. Thank you, Member Chang. Any other question on the case from the committee? Seeing none, I'd like to now. Oh, sorry, Vice Chair Lee.
I had one. I just had one comment that I just noticed when I was last reviewing it, and all my comment is it's not about the extension or not. It was just a correction on the topography map. It stated that the house was in the city of Arcadia, so I just wanted that to be noted. I don't know if anything else was incorrect, but I just had noticed that, so I wanted to make a comment on that.
Thank you, Vice Chair Lee-Kon. Good catch. I trust staff will take note and then communicate with the applicant to reflect all information on the case is proper and correct, since it's part of the legal document. Thank you. Any other quick question or heads up? Is it Mr. McEwen?
Yes, I'm with the city attorney's office. And it's nice to be here tonight. I just wanted to raise a procedural point, since there's a committee member who is absent tonight. There are two alternates. Has a decision been made, or there been a procedure in the past as to how you select an alternate? Because I know on the planning commission meetings that we do utilize the alternate when there is someone missing, so that you have a full 5-member committee making the decision.
Thank you, Mr. McEwen. Yes, we do have the tradition of appointing one of the 2 alternate members to become a voting member in case of an absent committee member during the meeting, and there's intention of appointing one, but we sometimes would appoint it when the discussion is over. So I think I'll be happy to appoint one if staff think it is appropriate for this case.
Yes, whenever at the vote or currently would be fine.
Right, that is fine. So I think just for procedural sake and make it just easier since we're on this topic, I'd like to appoint Rick Chow to be on case 1 and then Tony Chow on even number cases. So I think it'll be easier going forward. Okay, so Rick Chow for odd number cases and then Tony Chow on even number cases. Okay, so please take notes. Appreciate that. Okay, thank you all. So again, any further question or procedural issues on case number 1 for staff? If not, then I would like to move on to the next procedural step, is to invite the applicant or the applicant's representative to present the case to the committee. Thank you. Is the applicant or the applicant's representative present tonight? If you are, you're welcome to speak up and share information with the committee and general public.
Yes, I just wanted to say I really appreciate everyone's time. Thank you guys so much.
Sorry to interrupt you. Could you please cite your name and address, please, for procedural sake?
Yes, my name is Lee. Last name is Wei. The address is 1270 Oxford Road, San Marino. Very sorry, asking for this extension because, all the reasons, pandemic, everything going on. And so I really appreciate everyone's time tonight. Thank you so much.
You're welcome. And thank you for bringing up the case to the committee. So is there any question from the committee to Ms. Lee, please?
Oh, I'm sorry, I didn't hear it.
Any question from the committee to Ms. Lee at this point? Yes, committee member McKay, please.
Thank you. Did you note, I don't know if you noted because we were in the staff discussion, but did you note committee member or Vice Chair Lee-Kon's comment that there is an error on the topographical map regarding the city, that it says City of Arcadia?
I will definitely let my architect to check again and to see, where is coming from, why is Arcadia? I didn't know that. Sorry.
So for the record, which becomes a record of the city, if you could have that corrected is I guess what the committee's requesting.
Definitely, I will review it and talk to my architect if there any other mistakes.
Thank you.
Great.
Thank you.
Thank you. Along the line, I'm not saying it is a mistake, but I just want to check with Ms. Lee that on the residential information sheet page of your package, it does say that the owner is the Oxford Trust. I do not quite recall seeing that title. Rather, I thought it was under your personal name or something of individual basis. So I would just like to check with you, is there a change in title ownership or procedurally during the process, or is it part of the delay cost?
No, it's like, the property is under our family trust. but I'm the owner of the trust. Yes.
Okay, understand.
Nothing changed. Yes. Thank you.
Okay, good. I just want to be sure. Thank you. Any other question from anybody from the committee? Alternate member Rick Chow, please.
Thank you, Chair. I do have a question regarding the plan, and from reading the notes and also my recollection, this was a conditional approval. So the dormers will be eliminated. I just want to confirm that. Also with the question that, is it necessary that we change the plan, the drawings and the rendering? So that's my question.
Thank you,
Oh,
Ms. Lee.
I'm sorry. I think that's the old, we submit to the DRC, but we have no dormer right now. But in the record on the profile, I am not sure why still the dormer is still there. But I can asking the architect to revise to with the city to update the rendering.
So there is a new
No dormer.
revised plan that has no dormers, right? But
Yes,
it's-
I think with the city, this is Eva used to work for the city. So after the DRC approved, which is no dormer, I don't know why it didn't update it.
Okay, well, thank you.
Thank
So I
you.
guess I would have another question. I don't know if I can, at this point, ask staff, is that something that we can approve extension without having the current version of the plan?
Yes, I would like to clarify for the record that the plans that was attachment number 1 was the plans that were approved at the last design review meeting for this project. And at that meeting, the DRC, as a condition of approval, requested the removal of the dormers. So on attachment number 2 is the approval letter that states that the dormers must be eliminated. So yes, the plans aren't updated to the conditions of approval, but that's because I only copied and pasted the last plans the DRC saw. Once the plans go through formal plan check and come routed to planning, yes, I will verify that the conditions of approval are adhered to and the dormers are removed.
Okay, thank you.
Thank you. Any other questions for the applicant from the committee at this point? Seeing none once and seeing none twice, I'll close the current question session and presentation from the applicant and move to public comment session. Is there any public comment that the staff may see over the internet or through messages?
You're muted.
Yeah,
Sorry, I
Yep.
didn't see anything through the messages and
Okay.
there's nothing in my email.
thank you so much. As a result, I'll then close the public hearing and begin committee member the discussion. Committee member McKay.
Thank you. I could support the continuance under the circumstances and for the reasons that the applicant has provided. Thank you.
Thank you. Alternate member Tony Chow.
I thought were you going with Rick on this one?
Yeah, any comment you want to
comments.
make for discussion
Oh,
session of the
no,
committee?
sorry about that. Yeah, no, I can support it given the conditions.
Thank you. Alternate member Rick Chow.
Yes, I can also support it. I don't know if when we go to the vote, do we need to list the conditions to make sure the conditions are being followed? And also, I don't know if we want to make sure that if indeed there's a mistake stating Arcadia instead of San Marino, if that needs to be made into a condition. Also, to note the plan needs to properly reflect what we're approving for the extension. So that's kind of my question, but I can support it.
Thank you. On that subject, I'd like to ask staff and Mr. McEwen to guide us as to whether the 2 points, namely the wrong address, the city is wrongly typed as Acadia, as well as an updated plan needed to be attached to the committee for review in case there is a continuance for next meeting.
I think you can just approve the staff recommendation to grant the extension. If there's a mistake in terms of a city misnamed, if it's Arcadia instead of San Marino, that can be easily fixed. I don't think that really needs to be called out right now in the motion. And then I think the recommendation is just to approve as is. So you can approve the extension or just move to approve the extension as recommended by staff.
Okay, we can let the staff take care of the rest of the administrative issues as noted. Thank you. Committee member Chang?
Yeah, I can support the extension. I think the extension is not tonight, is not to review any modification of the plan. Whatever was approved stays the same condition, and we're just extending the time for 9 months only, so I can support it.
Thank you. Vice Chair Lee-Con?
Yes, I could support the extension as well.
Thank you. And I can support the extension as well. So let's see if there's any motion from anyone from the committee. And again, Rick Chow would be a voting member for this item. Anybody want to make a motion?
Yeah, I'll make a motion.
Please go ahead.
I'll move to approve DRC 19-91 extension request for the design review case. And as staff noted.
Thank you. Anybody second?
I'll second the motion.
Thank you. Committee member Chang second. Let's have a roll count. Staff, please.
Yes, and just for our minute records, the first motion was done by committee member Rick Chow and the second was done by committee member Raymond Chang. And roll call, Chair Wong,
Yes.
Vice Chair Lakin,
Yes,
committee member Chang,
Yes,
committee member McKay,
Yes,
and alternate committee member Rick Chow.
Yes.
Thank you.
Thank you. Motion approved. And now we are moving on to the second item of the agenda, which is to approve the minutes of the DRC meeting dated June 15, 2022. Staff, I believe there's just a direct voting procedure, correct?
Yes, unless there was an issue with the minutes. This is the first time that I am presenting the minutes, and so it wasn't clear at the last meeting who made what motions just based off voice. As today, I have been trying to verbally notate who is making what decisions and times as I am making the minutes, but in the future, our interns will be making the minutes and they're not familiar with voices. So if there's any corrections you'd like us to make, I can make it for this meeting and go back and listen to it. But if you would like to approve as I currently wrote it, we can do that as well.
Thank you very much. And on that, committee member McKay?
I do have some corrections I'd like made to the minutes before they're approved, so I don't know if others do as well, but I would like to.
Yes,
on
please
that.
bring it up.
Okay, well, the property on Somerset needs to be denoted as Somerset and not maintaining that typo that was in the staff report. It's, I don't have it. Let me pull it up. The item on Somerset.
Item number 7.
Yes, correct. Could the address be corrected to reflect the correct address of the property to Somerset?
I didn't realize that was
Do you see that?
2998 Somerset Place.
I think it was spelled misspelled.
It was spelled in the staff report and it's been continued to the minutes, and I wanted it corrected for the minutes.
Okay, let me verify this for you.
This is page 4 of 5.
It says summer rest,
Do you see
summer rest, summer rest.
Okay, Somerset. Okay,
Somerset?
the typo's within Somerset, not the address. Okay,
It is the address. It's the name of the street is
the
missing.
name of the street.
Oh.
Yes.
Yes. And then secondly, there is a quote of mine on Lorraine Drive, item number 5. And that should be precedential value. Not presential,
Okay.
precedential.
In that paragraph on number 5, I see that.
Yeah. PRECENDENTIAL. Thank you.
Thank you, Committee Member McKay. Is there any other committee member want to bring up certain observations or comments on the agenda of last meeting? Please feel free. Going once, Committee Member McKay.
I have another question. I noted that on each item, there was no note that there had been committee member discussion. It appeared that it had gone from public comment or the people who presented from the public on the application straight to the vote. Does it not make sense to note on each one of these that after committee member discussion, the vote was held? Because that was certainly the case. As you can see from the time when the meeting started to the time the meeting ended, there was extensive discussion on all of these.
I followed the template that the city clerk gave me for city council minutes, and they don't have that additional section. I
There's no
can,
note that there is just discussion after that there's discussion amongst the committee.
I followed it.
Yeah, this is Isidro. Sorry, I'm actually literally mobile, so I apologize for not being at the meeting. We can take a look at that again, based on what the format is for Planning Commission and City Council. The minutes have been tailored in that format, so we'll take a look at that. We'll coordinate with the city clerk, and we'll see what we can do, if anything.
Thank you.
Thank you.
You. Good comments. Keep coming. Thank you, guys. Anybody else may have anything to add? Okay, I do have one which probably is a for collective discussion, including Mr. McEwen. I've been to various different kinds of meetings in different civil bodies, and I usually see approval of the previous meeting minutes being the very first item, because then we clear the history and then move forward with what is coming at us. So I'm a little bit more used to that, but of course I'm not saying no to this format. I just want to see if that would make things easier, so that from a timeline point of view, we take care of history and then move forward from what is presented to us. Is it the San Marino format that will put other agenda items before the approval of the previous meetings, or any particular reason for that?
You can do it any order that works for you. This was listed as a consent item. So typically what we tell council members, planning commissioners, when we're dealing with items on the consent calendar, is that all those matters are deemed routine and can be adopted and acted by one vote. So you can do it all at once. In this case, obviously, there was discussion that needed to take place regarding the extension, and then discussion with regard to the minutes. So appropriate the way that you handled it. The order in which you do it is really up to you. If you feel more comfortable putting the minutes first, that's fine. If you want to put it as a separate agenda item, usually it's on the consent calendar. That's very typical. And then if there's a question that's raised, if there's a mistake, then that item can be pulled from the consent, and then you would vote on the remainder of the consent calendar, then come back to whatever item or items that you pulled for special discussion, which is basically what you did tonight. And so the way that you did it tonight's fine. I guess if you'd like in the future to have the minutes as the first item on consent, then it's totally fine. But either way will work in terms of review and adoption of those minutes.
Great, thank you. Yeah, I think since both item 1 and item 2 are consent items, So it is fine for the approval of the previous meetings minutes to be the second, but if there were some other current items to be discussed and approved, then it definitely would, I'd like to see the approval of previous meetings minutes be before the current cases to be discussed. So if staff can kind of take note with the community director, I think that would be great. And I also welcome comments from the committee as well, if there is any other views on this administrative subject. Okay, sounds like not. Then let's have a vote. See if we can pass the approval of the previous meetings minute. Anybody have a motion for that?
I'll give it a try. I will move to approve minute for June 15, 2022, as presented with amendment stated.
Thank you. Anybody second?
I'll second.
Thank you. Committee member Chang moved the motion, and then committee member McKay second. So let's have a vote.
Chair Wong,
Yes.
Vice Chair Lakin,
Muted.
Yes.
Committee Member Chang,
Yes.
Committee Member McKay,
Yes.
and alternate committee member Tony Chow.
Yes.
Okay, motion passes 5-0.
Thank you. Thank you, staff. Now we are moving on to agenda item number 3, Community Development Director's Report. Mr. Figueroa, please.
Mr. Chair, thank you. And thank you, DRC committee members, for your attendance today. Just a couple of items of interest. The project at 2174 Melville Drive, which was denied, and I believe it was denied in the last meeting, has submitted an appeal to the Planning Commission. Staff will be processing that appeal and will inform you of the date in which it will be going before the Planning Commission. Secondly, staff is in the process of interviewing for the 2 assistant planner position vacancies. So hopefully we'll have those vacancies filled pretty soon. And after that, we'll begin our recruitment for the senior planner position and the management analyst. That concludes my report, and I'm available for any questions.
Thank you, Director Figueroa. Anybody from the committee may have any questions for the director, please? I have one, I think, for the interest of the general public, is that Director Figueroa, we understand that the shortage of staff and the staff turnover in previous months, and also I'm aware that there are a fair amount of backlog cases, both the Planning Commission and the DRC. So would you be able to give us a quick overview as to where do the departments stand as to number of cases backlog and things along the line, so that the committee and the public can be prepared? Thank you.
I don't have a number for you, obviously, with the staff turnover and only one full-time planner on staff right now. It's difficult to give a assessment in terms of when these will be coming before you. We do have the help of a land use consultant that has assisted us with the review, primarily ADUs and some projects that have gone before Planning Commission, and we'll be hopefully using them to help us with the backlog of all other applications. But unfortunately, I don't have a number for you right now, but we are in the process of hopefully having the land use consultant helping us through this wave until we have staff or fill those vacancies that we have vacant right now.
Thank you. So is it correct to say that the land use consultant would be helping both the Planning Commission as well as the RC?
Yeah, as much as possible. Again, we have a limited amount in our contract for them. We are talking with the city manager's office to move forward with a contract that would have to go before the city council. So there might be some lag in between in terms of what they can do, but that's the plan at this point.
Thank you. And in terms of these additional external resources, is it going to be a professional firm providing multiple individuals helping both bodies, organizations, or it is basically a one person from the professional firm helping out both the planning commission and?
No, the land use consultant has multiple staff members that will be assigned to the city to assist.
Thank you. Thank you for the update. I think it is a welcome note for the committee as a whole of San Marino. Thank you. Any other committee member may have questions for the director at this point? Alternate member Rick Chow.
Sorry about the size of my hand. I have a question for Mr. Figueroa. You mentioned about the appealing process. Melville is appealing to Planning Commission. So is it kind of the procedure now that if any cases that's denied by DRC, and then if the case is getting appealed, we'll get notified? The DRC will get notified?
Well, the purpose of the director's report is to keep the committee informed of things that are going on in the planning division, specifically things that are related to DRC. And because this is a DRC matter that went before you last meeting and an application was submitted, I feel that this is something that the committee should be informed of. We shouldn't go beyond discussing that, obviously, because it's not an agendized item. But again, my goal is to keep the DRC informed, just as my goal is to keep the Planning Commission informed of any appeals that go to City Council that from decisions made from the Planning Commission.
So depends on the frequency of director's report. We may or may not know other cases if there were other cases.
Well, the intent is that that at any point there's an appeal that from a DRC determination, that I would inform you of that and the outcome.
Okay. Yeah, because that would be very, very helpful, and we haven't really had that before. And I think the request was kind of floated out there before. And another reason I'm asking tonight is because I've heard, I don't know if it's accurate, I've heard that there are at least one other case that was denied by DRC that's being appealed.
Not to my knowledge, we can take a look at that. Since
okay.
My arrival, this is the one and only DRC appeal. Whether something was appealed previously, I don't know, but we can find out.
Okay, thank you.
I could add to the record, at least I think it was before Dr. Figueroa came on. There was a denial of a comp shingle case on 970 Sherwood. And they appealed, and so they are proposed to go before the Planning Commission for July.
Right, that's actually what I heard. So yeah, thanks for the confirmation. Thank you.
Thank you all. Again, any further questions for the director on his report? Any other related question, issue of concern? Going once, going twice. I thank you all for the input for this agenda item, and I want to thank Director Figueroa for his time and his report. So as a result, we are ready to move on to item number 4 for tonight. Is we have our city attorney to make a presentation regarding the findings of recent housing legislation. I believe Ms. McEwen, this is your floor.
Thank you, Chair Wong. It's a pleasure to be here tonight. I work with Joe Montez at the law firm of Burke Williams and Sorensen. For those of you who don't know, Joe is the city attorney. We took over late last year. I've been helping with planning commission meetings since then. And Joe and I have put together a presentation for you on legislative findings and quasi-adjudicative findings in recent housing legislation. And I'm going to ask if Camelia can put that on the screen. Hey, Camila, why don't we go to the first slide? So we're bringing this presentation to you because there have been a number of recent pieces of legislation that really impact what you do as a design review committee and what the planning commission does and what the city council does with regard to housing development projects. The recent trends in those pieces of legislation include a significant decrease in local control over residential development projects and a corresponding increase in the level of scrutiny of local land use decisions that involve housing projects. So who is doing the scrutinizing? It's the HCD's enforcement division, it's housing advocates, it's developers, and finally, it's the courts. The legislature, beginning in 2017, to address the state's housing crisis, passed a number of bills that substantially amended housing and planning laws in California. So initially, these bills were intended to make it more difficult for cities to deny projects or reduce the density of housing projects, and also to require cities that cities only apply objective standards to housing development projects that otherwise comply with the city's general plan and specific plans and other ordinances. As the legislation evolved, it actually really severely limited local zoning authority, and that's why it's significant and why we want to bring all of this to your attention tonight. As a whole, this legislation or this myriad of bills has really upended the interpretation of general plans and zoning ordinances. The Department of Housing and Community Development, HCD, has published guidelines that are heavily weighted toward the position of the development community. Those guidelines have not been challenged as of yet in any case that we're aware of. And as I mentioned, HCD has an enforcement division to enforce those guidelines and go after jurisdictions, cities and counties that it believes are not acting in compliance with state laws and regulations. Let's go to the next slide. So tonight's agenda has us looking at the legal context, and by that, I mean the context in which San Marino and its decision-making bodies, such as the Design Review Committee, make its decisions. And then we'll talk also about what your role is as a decision-making body, the importance of making findings to support your decision, what constitutes a finding, and how to make findings that will ultimately survive judicial or legal challenges. We'll go over the concept of ex parte evidence and ex parte contacts and how that can affect a fair hearing. We'll talk briefly about conditions of approval. That's probably self-explanatory. I'm sure you're very familiar with conditions of approval, but we'll talk briefly about what the standard is that you need to apply when imposing a condition of approval on a project. We'll also talk about due process requirements. It's probably a topic that deserves its own presentation all by itself. I will try to address the most important due process considerations tonight, and those would be notice and an opportunity to be heard, and also the right to a fair hearing. And finally, we'll talk briefly about the key pieces of housing legislation that have really changed the landscape for you as a design review committee and changed the landscape for the planning commission and city council as well. Okay, next slide, please. So what is the legal context for the city of San Marino? You probably know this. San Marino is a general law city as opposed to a charter law city. A general law city derives its corporate power from general laws that are enacted by the state legislature. A charter city, on the other hand, derives its corporate power directly from the Constitution, and that's subject, of course, to limitations in the city's charter and enactments from the legislature on matters of statewide concern. San Marino can legislate to protect health, safety, and welfare. This is known as the local police power, and that comes from the California Constitution. That's Article 11, Section 7, and that authorizes counties and cities to enact and enforce regulations to protect the public's health, safety, and welfare. Article 11, Section 7 states a county or city may make and enforce within its limits all local police, sanitary, and other ordinances and regulations not in conflict with general laws. Pursuant to that constitutional authority, cities and counties have a broad authority to govern, subject only to the limitation that they exercise this power within their territorial limits and subordinate to state law. And we'll talk in a moment about the hierarchy of laws within the state of California. A city zoning code is really one of the most well-established and well-recognized manifestations of the police power. A zoning code regulates all land use in the city. And among other things, as you I'm sure know, zoning code establishes various districts and contains various land use classifications for allowable land uses. So within each zoning district, the code will identify land uses that are permitted or as of right or permitted subject to conditional use permits or other types of discretionary approvals. And again, important, as we'll discuss in a moment, to keep in mind that any decision that is made pursuant to a city's zoning authority must comply with due process requirements. Next slide. So this is the hierarchy of laws and regulations that you'll come across as a member of the Design Review Committee. At the top of that hierarchy are state laws. We have to make sure that our laws are consistent with state laws, that they're not preempted, that they don't conflict or duplicate state law. State law is the at the top of that hierarchy. Just below that would be the city's general plan, which is the comprehensive long-term plan for the development of a city, and any city's zoning and land use decisions have to conform to the general plan. Just below that would be specific plans that contains certain specified details relating to land uses, infrastructure development, conservation standards, and then they have to relate to the general plan. Then lastly, we have our zoning code. And again, as I mentioned, that's the separation of cities into various zones and the regulation of buildings and structures and properties within those various zones. Next slide. So we'll talk in a moment about findings, but first I just wanted to address the difference between legislative and quasi-adjudicatory decisions. So legislative decision is one that involves the adoption of a broad, generally applicable rule of conduct on the basis of general public policy. So if you're adopting a zoning ordinance that is generally applicable, that would be considered a legislative decision. An adjudicatory decision is one that involves an individual based on facts that are particular or peculiar to that individual's case. It's a determination that is a result of a proceeding where there is usually by law a hearing that is required to be given, evidence that's required to be taken, and discretion in the determination of facts that's vested in the decision maker, in this case, the Design Review Committee. So the reason why that distinction is important is because there are fair hearing requirements that apply to quasi-adjudicative decisions that don't apply to legislative decisions. So a decision-making body that's sitting in a legislative capacity, passing a generally applicable rule or adopting a generally applicable rule is not subject to a fair hearing requirement, whereas a decision-making body that's sitting in a quasi-adjudicatory capacity has to be neutral and unbiased, and they are subject to fair hearing requirements. Next slide. So you probably remember when you were in school and your math teachers asked you to show your work. You couldn't just provide an answer. You had to show the steps that you took to get to that answer. And that's what we're required to do with findings for quasi-adjudicative decisions. You have to show your work. That serves a couple of purposes. One, it promotes transparency. So people in the public know how a decision was reached. Also, it's important because if we get challenged on a decision, we need to have a record to support how a particular decision-making body got to that result. So the basic requirement is that a city has to issue written findings in support of a decision on a quasi adjudicative or quasi judicial matter. There must be substantial evidence to support the findings, although I will note that a higher standard of evidence applies to certain decisions under the housing laws that have been recently adopted. But in general, the standard is substantial evidence. And what we're looking for in the findings is something, as one court put it, something that will be sufficiently detailed to, quote, bridge the analytical gap, unquote, between the evidence that is presented to you and then the final decision. So what, for example, a court would want to see is something that connects the evidence and the data and the testimony that was in front of you as a decision-making body, that connects that with your final decision. So substantial evidence as a standard is one you probably have heard of. It means that degree of relevant evidence that a reasonable person looking at the whole record that's in front of the decision-making body would accept as adequate to support a conclusion, even though another reasonable person might reach the exact opposite conclusion based on that evidence. So this is a lower standard of proof than what we refer to as the preponderance of the evidence. That's a standard that requires the evidence supporting a decision outweigh the evidence that would support a contrary conclusion. So in terms of numbers, although I think that you would find that that typically the courts have concluded that it's not a numerical formula, but when we think of preponderance, we usually are thinking of something that is, for example, if you're going to throw a number on it, you'd put 51%, something that it outweighs the contrary evidence, whereas substantial evidence can be something less than that. Let's go on to the next slide. So this slide is labeled ex parte evidence, but there's really, there's two aspects to it. One is ex parte evidence and ex parte contacts. They're similar. When I think of ex parte contacts, what we're referring to there is discussions that you may have with an applicant or a project opponent outside of a meeting. Ex parte evidence is evidence that is not in front of you, that might have been presented to you outside of a meeting. The basic rule is that boards, commissions, any decision-making body is supposed to base its decision on what was said at a public meeting or public hearing, which is the record that we have, that we develop for purposes of defending a decision, the administrative record. The reason that's the general rule is that we want all parties to be fully apprised of the facts, and that nobody who participates in the process, either as a project proponent or project opponent, gains an undue advantage, unfair advantage through private conversations. So all members of a decision-making body like the Design Review Committee have the right to hear everything that is said about a case. Everyone, including the applicant and those who support or who are opposed to a particular case, have the right to hear everything that is said about a particular project or case or matter, and they have the opportunity to rebut what was said or to support or endorse what was said. Now, having said that, the law recognizes that it's simply impossible to avoid all contacts on questions that may be coming before you. Commission members, committee members, council members are appointed and elected precisely because of their involvement in the community, their understanding of the legal issues, their knowledge of the members of the community, their familiarity with members of the community. So it'd be unrealistic to apply a standard that would result in disqualification for every ex parte contact that occurs. And it would be unrealistic to apply a standard that resulted in the nullification of any action that took took place if there was some ex parte contact. So there are some guidelines and rules that are in place that we recommend you follow in order to avoid any claims that you're a biased decision maker or that you've engaged in some improper outside discussion. Just number one, I guess the most important thing is to remember that the prejudicial effect of an ex parte contact is in the fact that the other side is not given an opportunity to respond or is unaware of the contact altogether. So in a lot of situations where an ex parte contact has occurred or some type of ex parte evidence has been brought to a decision maker's attention, it's important to disclose that at the beginning of the discussion on that particular item. Unless there is some level of contact that leads to some incurable bias by the decision maker, then the ex parte contact or ex parte evidence is not going to be detrimental enough to the proceeding to result in someone's disqualification or to result in the nullification of an action taken. So important, so long as it doesn't result in that high level of bias, that you still disclose those contacts, that evidence, and that gives the other side an opportunity to respond. Now, the recommended course of action, of course, is to avoid as much as possible ex parte contacts, ex parte communications with project applicants, project opponents, and you can just simply end the communication and explain to that individual that you can't talk about a matter that is currently before your particular committee or is about to come before your committee, and that you just simply can't discuss those outside of a public meeting. If the communication does occur, then it's important at the hearing, as I mentioned before, to disclose on the record the fact that the communication took place, and then you can share any substantive information that you may have received during the course of that contact. So any evidence that might have come your way, you can disclose that. And that gives people on the other side of an issue a chance to respond to that if they feel necessary.
Mr. McEwen, if I may, on this ex parte context or evidence subject, would you be able to say some example so that the committee may have a better grasp of it?
Well, if you happen to know someone or someone approaches you about a particular development that's going to come in front of you and maybe invites you to the property to look at it, and then gives you information about the background of the project, that would be just a good example, I think, of something you'd want to disclose on the record, so that you can let the rest of the committee know, and then any members of the public who are there for the meeting know that you had that discussion. Here's what was discussed, and a lot of times that's the end of it. You know, I think, again, as I mentioned, it's not possible to avoid all contacts. And I will get into that discussion a little bit more in a moment when we talk about due process and the importance of providing a fair hearing and an unbiased decision maker. We'll get into that a little bit more, and I'll talk about what the case law says, and I think that'll further illustrate to you what the boundaries are. They're not easy boundaries to draw because the cases, I think, in my view, are still evolving in that area. But we'll discuss that a little bit further when I get to the due process component.
Yeah, thank you. Because I just want to bring it up is because of the current COVID situation and the virtual meeting setup, that we no longer have the open forum opportunity for potential applicants to bring up cases for a maximum of 2 committee members to share some insights without any indication of approval, disapproval, anything with regard to decision-making process. So now that the general public is not having this avenue, I just want to see if there is actually any legal ramification to the city, or the department is actually thinking of an alternate avenue so that communications and information channeling is going on with the correct conduits. Thank you.
Sure. And I will talk a little bit more about the due process implications of those type of discussions or public statements in just a moment. The last piece of advice on the ex parte evidence, ex parte contacts, and this does kind of blend in with the due process issue, is that if there's some communication, some ex parte contact or evidence that leaves you unable as a decision maker to base your decision solely on what the evidence is that's presented to you at the hearing, then you're no longer an unbiased decision maker. And if that's the case, then the recommendation would be that you recuse yourself from the meeting, that you not participate. You'd have to leave the room. It's not enough to just merely abstain from voting. So that's an unusual set of circumstances, but that would be the last resort if you felt that whatever had occurred is going to impact your ability to be an unbiased decision maker, then you'd have to recuse yourself at that point. Let's go on to the next slide. Camille, can you move to the next slide, please? Yeah, thank you. So as I mentioned before, conditions of approval are pretty self-explanatory. Many projects that you would consider would have some condition of approval. Some are pretty standard. They're generally prepared by staff, and you'd see them from project to project. Some are more specific. The standard that you have to keep in mind when it comes to conditions of approval is that it does have to have some nexus to the project, that it must be related to an impact of the project, and it also has to be proportional to the impact. So you can't impose an onerous condition, an undue burden on someone when the impact itself doesn't call for that level of a condition. So that's just something to keep in mind. And certainly if you have questions about a particular condition, you can ask staff, or if someone from the city attorney's office present for the meeting, you can ask them as well. Go to the next slide. So as I mentioned, due process in and of itself is a very big topic for members of decision-making bodies like a design review committee, planning commission, and certainly city council. The basic requirement for due process is notice and an opportunity to be heard. And that applies not just in the types of decisions that you make as a appointed body, or the planning commission makes, or the city council makes, but this really applies across the board to all types of administrative decisions. It applies in court. I mean, that is basically the linchpin of due process, is that a person not be deprived of any right or liberty without first having a notice of that and an opportunity to be heard. So that is something that we remind even in the context of code enforcement when it comes to imposing a fine or declaring a property to be a nuisance. Before we take any adverse action on some property, we give them, the property owners, the tenants, a notice and an opportunity to be heard, unless there's some imminent threat to life and safety and it's an emergency. But again, that's all I heard in law school when it came to due process, was notice and an opportunity to be heard. And so when there's ever a question about whether a proceeding has been fair or not, you always go back to that basic principle. Was there notice? Was there a fair opportunity to be heard? Now, in the quasi-adjudicatory context in which you make a lot of your decisions, there's another requirement, and that is that there be an unbiased decision maker. And that's where it can be a little difficult to determine whether due process is being met. And the reason is the courts have not always been consistent with what the standard is for determining whether you have an unbiased decision maker. Now, there's some standards that are very clear, like in the Political Reform Act, there's certain standards that apply, which you can look at and almost formulaic and determine whether you have a conflict of interest that would prevent you from voting on a particular matter. Perhaps you live too close to a particular project. So those standards are very clear and well, I should say relatively clear compared to the other standards that I'm about to talk about. The government section 1090, which refers to improper contracts, those again have fairly straightforward black and white rules that apply when you can be participating in a particular decision if it's going to affect something that you have a financial interest in. Where it gets hard is where someone says that you may not have a statutory conflict, but you have a what we call a common law conflict. And when we say common law, is usually referring to a body of law that's developed over time through a series of court decisions. And that's really what we're talking about when we talk about unbiased decision maker. You know, years ago, I had a case for a city in Northern California where a council member was accused of being biased against a particular project. Actually, in that case, he was accused by the proponents or opponents of the project as being biased in favor of the project. And it really resulted from an argument he got in with the project opponents at a city council, at a planning commission meeting. So the project was being approved by the planning commission. A council member was there. It was a very emotional meeting. There were a lot of opponents to the project there. The council member who was at the planning commission meeting as an observer got into a shouting match with one of the opponents. And then the matter went up on a split vote. It was approved, went to the city council, and the city council approved it. And the argument was that that council member, because of his intemperate outburst at the conclusion of the planning commission meeting, was biased, that he couldn't be an unbiased decision maker. And the reason it was significant is because the project was approved 3-2. So his vote was critical in that situation. And the court agreed with us that that didn't rise to the level of an unbiased decision maker, even though it had gotten a little emotional and a little heated, that based on the case law that we presented to the court at the time, 12 years ago, that you needed to show something more in order to be able to establish that a decision maker is going to be biased and unfair. So traditionally, it was more than just having made a statement about something prior to a project coming to you. There were a number of cases. One of them dealt with a project, and this is in the 70s, went to the California Supreme Court. There was a claim that 2 of the council members were biased on this project because they had expressed their views in opposition to the project prior to it coming to the city council. And the court said, no, that's not enough to show undue bias, because we expect our council members to take positions on matters of public importance. And if that was enough to disqualify them, then it would be very difficult for people to serve in that capacity. There were other cases that followed up on that. So it did appear that making these pre-decision statements, pre-hearing statements regarding particular project was not going to be enough by itself to create a conflict of interest, a common law conflict of interest that would require that decision maker's recusal from the entire process. Now, what's made it more complicated is there's some more recent decisions that take the view that prejudgment or pre-hearing statements can be sufficient to establish bias. One of them was from the city of Los Angeles, and that was a situation where a planning commissioner had authored an op-ed piece in a local newsletter that was opposed to a project. Now, in that case, the planning commissioner had not been truthful, apparently, according to the decision, about his authorship of the article. And the article was written anonymously, but I guess it had come out that the planning commissioner was the author. And initially, that planning commissioner had not been forthcoming about his involvement in the article. The article was very much opposed to a particular project. That decision was challenged in court, and the challenger won on the ground that the planning commissioner had been biased. And what the court said was that the authorship of the newspaper article alone, standing alone, just the mere authorship of the article, was enough to give rise to an unacceptable probability of bias. Why I think that's significant, they really didn't discuss those other cases that I mentioned previously. They went strictly by the fact that the planning commissioner had written the article. So something to kind of keep in mind as a red flag is that you can run into trouble just by virtue of making pre-hearing statements. And again, that was kind of confirmed a little bit more in a more recent decision out of Newport Beach, where a city council member had expressed displeasure with a planning commission decision, had actually appealed the decision himself to the city council, and then read a very lengthy statement which he explained his opposition to the granting of a CUP for a harborside bar. And the court there found that that activity, those actions by the council member, were enough to show bias. So in light of those two cases, statements by a council member or a planning commissioner should be avoided as a general rule. So pre-hearing statements for or against a project are things that you want to avoid. And I guess really what comes out of that, and this goes back to the questions that Chair Wong was asking a moment ago, is how do you draw that line when it comes to contacts that you may have with project proponents, opponents, before something comes before you. And I think what emerges from those cases is a rule about taking an advocacy position on a particular project. What you want to avoid is taking an advocacy position for or against a particular project before it comes to you as a hearing matter. And that's clearly what happened in those two cases, in the Los Angeles case and the Newport Beach case, was the decision makers who found themselves on the wrong end of those decisions clearly took an advocacy position. They were in both cases advocating against a particular project. So I think when it comes to land use projects, council members, planning commissioners, design review committee members, you can take positions, but you have to be careful to maintain an open mind. And you don't want to take a position to the extent that it becomes an advocacy position. That's not an easy line to draw. I totally recognize that. And you have to keep in mind that as a decision maker, you can be an easy target for someone who is upset by a particular decision one way or another. So I just urge all of you, and I've urged the Planning Commission members, and I know Joe Montez has urged the council members in his presentation, just to be cautious when it comes to making statements, taking positions, because they could be construed as taking an advocacy position for or against a particular project. Any questions regarding due process?
I do have one, Mr. McEwen, if I may. Taking an advocacy position, would that include, for example, anybody from the Planning Commission or the DRC to write to the city newspaper in the editorial section that comments from the city saying, oh, I like using, for example, natural material, building material for properties in town, and cite some examples, but not using the capacity as a committee member or commissioner, but people know that the author actually is a current member, for example, of a certain committee. Would that contribute to a advocacy position and cause unnecessary repercussion?
Well, it could if it was relating to a specific matter that was in front of you. You know, general policy positions are a little different. But when you're talking about a particular project, then you could find yourself in the same position that the planning commissioner did in the Los Angeles case I just mentioned, or the same position that the council member found himself in the Newport Beach case. So I think when in doubt, you might want to check with the city attorney's office or with the city manager's office and get input before position is taken publicly. It's not uncommon for council members to have pieces in the paper, but I would just caution you to avoid taking that, like I said, an advocacy position for or against a particular application that is going to be, it's either in front of you presently or about to be in front of you.
And thank you. And as a full disclaimer, disclosure, I'm not trying to encourage or discourage anyone from writing anything, but I think your guidelines would be helpful. It's just general direction. Thank you.
Steve, I have one quick question. There's Raymond. Earlier, I saw that the decision made has to tie it in with evidence. Reading the minutes, how we took the minutes tonight, is there enough information to be retrieved, this evidence on a decision-making process? Or it's going to be, if somebody challenged that, will we have to go back to the tape and re-listen to the meeting? Because by looking at the minutes, as you can see, it's just the decision and the voting, and no discussion was put in there. So whether the project is denied, approved, or continue, there is no evidence of any of those evidence.
Well, I've seen minutes in different formats, some with more detail than others. The minutes are an official record of what occurred at the meeting, but if there was ever a challenge, one of the first things I would do would have the recording transcribed to the extent possible. So I know with city council meetings, and I was working on an administrative record today for another city. What we did in that case, we had these were Zoom meetings, so they were done recently. But we took the video recording and had a court reporter transcribe. So we have a transcription. So the administrative record, if when there's a challenge, we have to put together the administrative record. In that case, it included not only the meeting minutes, the approved meeting minutes, but also the transcription of the meeting. So you have everything that was said in front of the court. So we would look at both of those. And then going forward, I can talk with Camelia and Isidro and the city clerk about what exactly we would want to put in the meeting minutes. But if there was ever a challenge, since it's been the practice of the city to record these meetings, you do have that as a further set of evidence as to what happened.
Right. I guess that they will keep that tape or the recording for a long period of time, so we don't lose that recording. That's, I guess, the only concern is that. Yeah.
And the staff report as well, following on committee member Chang's question, the staff report is part of the record as well, correct? Because referring to it constantly throughout our discussion.
Absolutely. So not only that, so when we put together a record, it would have the notice of any meeting that was going to take place. It would have the agenda, the staff report, any written public comments that were received, any oral comments made at the meeting. It's all part of the record. So sometimes the evidence that you need is included in statements by members of the public. And you can make a decision and you can rely on evidence of that nature that's presented during the meeting. And that would go to the substantial evidence test. So that's another important element of the record. We'd have the minutes, any official action, whether it be a resolution or in case of a city council, any final action they took on an ordinance or permit, all of that becomes part of the record. Anything that was in front of the decision maker at the time the decision was made is part of the record.
Excellent, thanks.
Thank you very much. Very good.
Even on the bottom of this page, sources of income, I'm not sure if I've missed it. Are you talking about non-arm's length transaction or related party transaction, or is something else?
So the bottom bullet points where it says most common are the 500 feet, 1,000 foot radius sources of income. Those refer to statutory and regulatory common law. I'm sorry, statutory and regulatory conflicts of interest. So, you can't be within a certain distance of a project, nor can a project that's in front of you. You can't take action on something that's going to have an impact on your income. And those formulas are all specified in the Political Reform Act. And then you can't take action on any anything that would affect something that you have that affects a contract in which you are an interested party, and that's Government Code Section 1090. So those are the statutory regulatory conflicts. The common law conflicts are the ones that are a little squishier, and the boundaries are a little harder to determine. And it used to be that you had to really engage in some extreme conduct for it to rise to the level of unacceptable bias. There were a couple of cases that we would rely on regularly as sort of setting the boundary, where somebody had a project in front of a city council in LA County, and one of the council members was going to have his view affected by that project, and had a long history of bad blood with that particular neighbor. That was determined to be unacceptable level of bias. But now with these more recent cases, it can be something a little bit more mundane. Just an op-ed piece for or against a project can disqualify you or rise to the level of bias. So those are the things to keep in mind as you go forward with projects that are in front of you, and just keep in mind that you need to be an unbiased decision maker, and to the extent there are any questions you have about whether there's statements you've made on a project that you might be concerned about, you certainly can bring them to staff's attention. That can be brought to our attention as well if it rises to that level.
Yeah, I think the committee has been observing the radius rule pretty, readily and firmly. But this is a very small town, right? So if a committee member is the chair of the high school soccer booster chair, and then the case belongs to the football team captain's family, for example, I mean, would that cause anything for recuse, or this is no monetary relationship, no distance relationship of the two properties, so it doesn't really contribute to that situation?
Yeah, well, every case is going to be different. We would always approach these questions on a case-by-case basis. It doesn't sound like that would be a statutory or regulatory conflict. Then the question is whether that's going to create the appearance of bias. That's another issue that sometimes comes up, is that even though you may feel like you're totally unbiased, there are situations where there might be some connection with an applicant or a project proponent or opponent that it gives rise to an appearance. And that's another thing you just take on a case-by-case basis. In a smaller town like San Marino, where it's not uncommon for you to know lots of people in the city, applying a strict application or interpretation of that rule could end up disqualifying you in too many projects. And so it wouldn't be practical to do that. And it's just something that you'll need to use your best judgment on. But again, I think what the takeaway is that you want to avoid the advocacy position. And then if there are questions about whether, or if someone raises a question about whether you can be fair or unbiased, then that's something that you might want to take up with staff ahead of a meeting, or even if during a meeting that issue comes up, you can always take a break and we can address that issue so that we can avoid any potential problems down the road.
Thank you. I think we should let you move on to the next page. Thank you.
All right. So these are the pieces of legislation that I was talking about that have had such a big impact on what the Planning Commission does, what the City Council does, and what you do as members of the Design Review Committee. We'll go through 4 of these. I'm not going to mention SB 9 tonight. We'll go through the Housing Accountability Act, Housing Crisis Act, recent changes to density bonus law, and then SB 35. And you'll see a lot of similarities and trends in what's happening with these particular pieces of housing legislation. Camille, can you move to the next slide? So what City Attorney Joe Montes wanted to stress in these presentations was there's certain trends in definitions that have been enacted in these pieces of legislation. And these trends can be really summed up as less local control, more residential development, higher density, and faster processing of permits. And if there was one other trend I'd add to that, and that is that there's an increasing burden of proof when it comes to the findings that have to be made related to housing developments. Remember, previously I mentioned that the general rule when it comes to quasi-adjudicative decisions, whether it be in front of design review or planning commission or city council, is substantial evidence. And that is generally considered a very lenient pro-city standard. When it comes to housing developments, the state is making it harder and harder for cities to deny housing projects and is requiring more proof to justify decisions that deny housing development projects. And it's also creating standards for what we consider to be objective standards. It's creating a definition of an objective standard that really in practice allows a lot of argument over whether, it actually is an objective requirement, whether what we've adopted as objective requirements, whether they actually are objective. So there's lots of obstacles that we now have to face that we didn't have to face previously. And maybe not fair to refer to them as obstacles, but it's just increasing the level of proof and the level of work that we have to put in when it comes to evaluating and approving or denying these projects. And mostly the difficulty comes when a decision is made to deny a housing development project. Camille, can you go to the next slide? So the Housing Accountability Act was adopted in 1982. And then as originally acted and generally still true today, the HAA provides that when a proposed housing development complies with applicable general plan, zoning, development policies, the local agency can only disapprove that project if it finds that that project would have a specific adverse and unavoidable impact on public health and safety. That has been the rule generally since it was adopted about 40 years ago. It's the recent 2017 amendments that are of concern to us and that have altered, some might say drastically altered, the landscape for local governmental decision-making bodies. So one of those changes is that the legislature has added a provision requiring that an applicant receive timely written notice and an explanation, a written explanation, if an agency considers a proposed housing development project inconsistent with applicable objective standards. So you have to let them know right away. That's what's set forth in the Housing Accountability Act. It also has heightened fines for bad faith disapproval of a project. And as I mentioned before, it's increased the burden of proof for a finding of an adverse effect on public health and safety. So with these changes, a local agency now has to justify its decision to disapprove a project by a preponderance of the evidence rather than the old substantial evidence test. And then lastly, and perhaps most importantly for our purposes, there's a new provision that provides that a housing development project shall be deemed consistent and compliant and in conformity with applicable general plan requirements, programs, policies, zoning ordinances, if there's substantial evidence that would allow a reasonable person to conclude that the housing development project is consistent, compliant, and in conformity. So previously, you could make that adverse impact finding based on substantial evidence. Now you have to make that based on a preponderance of the evidence. Conversely, if a reasonable person would conclude based on substantial evidence, again, an easier standard to meet, that the housing project meets those objective standards, then it's deemed consistent, compliant. So it just makes it that much harder for a city or county, local governmental entity to make that adverse finding that a project is inconsistent with applicable standards.
Mr. McEwen, I know many of the residents in Marino are very concerned about all these changes and whatnot, but look at the second bullet, is that the reduction of high density or other objective standards could not be used as long as they make the project infeasible. Does that mean infeasible in terms of financially? Because it is a two-way street. If somebody buys land too expensively, the developer has to go up and make it very dense. So it's going to hurt the community so much. So who is the onus on whom to make sure it is really something that is sensible.
So again, if the project includes affordable housing, then the city, county can't condition that project in a way that reduces height, density, or other objective standards that would make the project unfeasible. So that's something that, again, it's going to be on the city to make sure that they can, that the project is feasible. And I think it's going to be a very difficult standard to meet. Remember, all of these are being interpreted in a way that is going to favor the development going forward. So when in doubt, I think you can assume that the burden is going to be against the local governmental agency.
Right, I know, I've heard that many developers throwing into affordable housing units to be so-called as a shield to make the project go forward, but it is really not helping the community or the heritage of a city as we are seeing it, but it is maybe a subject for another discussion.
Yeah, no, and I understand it's again, it's a different landscape that we're dealing with now, and these laws are really designed in ways that are going to make it difficult to deny projects or to condition projects in a certain way.
Can I ask a question?
Sure.
How do they determine the affordable housing component? Go after what they approve it? If they approve it, then how do they like monitor this affordable housing situation?
Well, that would be, I think, similar to how we do it in other contexts. You'd have to have some type of a deed restriction recorded on the property. And I would maybe defer to Isidro on that particular question, how you monitor that going forward. But again, it's difficult to, once the affordable housing component is part of the project, it just limits our discretion in terms of being able to condition the project or deny the project. And then going forward, usually with affordable housing, there's some type of a restriction that is recorded on the property. But those I recognize can be difficult to follow. I don't know if Isidro is still on the line. I'd like to hear what his experience has been with that. Or Camelia, are you able to respond to that?
Sorry, Steve, it's me, Isidro. Typically you would have a deed restriction that's it's conditioned as part of the project. You have some sort of filing that would obviously make the unit or units available only to those target families that they're intended to. In some places that I've worked at, you have a housing department that specifically looks at that. We don't have that in the city, so it would be up to staff to make sure to monitor that, whether it be in cooperation with the county agency or by city staff.
Does that answer your question? Camelia, can you move to the next slide? So the next piece of legislation that I want to talk about was the Housing Crisis Act of 2019. That was enacted to jumpstart more housing production by accelerating the approval process, and that kind of limits local government's ability to downzone. It limits fee increases on housing applications, and importantly for our purposes, it states that when you have a housing development project that complies with applicable zoning standards, and so long as they're not seeking any exceptions or rezonings or other legislative actions, then there's a maximum number of public hearings that can take place on that project. It's a maximum of 5, and that would include informational hearings and appeal hearings. So again, this works hand in hand with the Housing Accountability Act, meaning these projects, as they come to cities, are going to be expected to move very quickly through the process, and it limits, for example, if you want to continue a project, you need to think twice about that because you need to count how many hearings have already taken place, and then proceed accordingly, keeping in mind there's that 5 hearing limit. Go to the next slide. So another housing law that's been around for a while, the density bonus law. This was originally acted in late 70s, 1979. It's undergone a number of amendments, especially some significant amendments recently. So the basic rule is that a developer can get certain benefits if the developer agrees to include a certain percentage of affordable housing units in a project. With the recent amendments, the density bonus law allows for additional units up to 50% above the maximum under that's allowed under zoning. There are incentives and concessions to reduce applicable development standards, including height limitations, setbacks. Other zoning code and architectural design requirements can be waived. There's waivers or reductions of development standards that would actually physically preclude construction of projects as designed. And then the new amendments provide for significantly reduced parking ratios. So what's significant now is that a local agency cannot deny a requested incentive or concession unless it makes a written finding based on substantial evidence that there's no actual identifiable or actual cost reduction, that there'd be a specific adverse impact on public health and safety or on a historic resource, or that the concession or incentive would be contrary to state or federal law. So this goes back to what we talked about previously about the importance of findings. And in the new amendment's going to emphasize that again here, that if you're going to deny an incentive or a concession or a waiver or reduction of certain requirements, that you have to be able to make the very specific findings, and you have to be able to support them with adequate amount of evidence. So again, going back to those rules we talked about when it comes to findings and being able to connect the evidence with a decision that is made. Any questions on this? Okay, Camille, you want to go to the next slide? So the last piece of legislation we'll talk about tonight is SB 35, and what that does is establish a very streamlined approval process for certain multifamily projects that include an affordable housing component. What's significant is that it's only subject to objective criteria and standards. I believe the city has adopted a SB 35 ordinance to provide for those objective criteria and standards in San Marino. Projects that qualify under SB 35 are not subject to a conditional use permit requirement, and they are subject to that expedited review process that is now common for these types of housing development projects. So that's the final slide. If there are any questions, I'd be happy to try and answer them tonight.
I'll start with the first one, and I hope I'm not opening a can of worm, but is there any reason you are not touching SB 9?
Well, we kind of focus on the ones that I think with SB 9, with the lot split, it's going to go to the city council. So for purposes of planning commission and design review, I think we focus on the ones that are going to be most relevant to what you're going to be faced with.
That's fair. And then on SB 35, is it something that City of San Marino is going to see potential opening for that to be applicable, knowing that it is basically a single family community?
Well, we just have to be prepared for that possibility that a project would come forward. So I believe what Joe and some of my colleagues did last year was adopt the ordinances, put them in place that would provide for those objective criteria that are required under that particular law.
Okay, thank you. Any other members of public may have question for Ms. McEwen? I think it's very informative and a great training session, well put together. Thank you so much for that. Going once. Going twice. I see no further questions from the committee. Mr. McEwen, thank you so very much for your time and effort for the effort. Thank
Oh,
you.
you're welcome. And if any questions arise, you certainly can forward them to Isidro and Camelia, and then they can forward them on to me. And it was a pleasure to be in front of you for the first time, and we'll see what happens in the future, whether I'm participating in future meetings, but hopefully I get to meet you all in person at some point.
Thank you very much. Great. So for tonight's agenda, we have covered 4 items as planned and agendized. So I want to ask staff if there's anything else that we may need to touch on before we adjourn the meeting. Camelia?
No, that's the last item, number 4.
Thank you very much. And fellow committee member, is there anyone who may have anything else to add or bring up?
I just have a quick question for staff,
Yes.
which is just, do you have any idea of how many projects we're going to have on the next agenda? Just for planning purposes.
At minimum, I believe around 3.
Thank you.
Great. So based on the manpower in the department and resources you may have, is it fair to say that we are still looking at between 3 to 6 items per meeting, plus or minus? I mean, not the whole year. 100% accountable with that.
Yeah, I can estimate that. It just really depends on the week and the month. There's just other projects that come up that are unexpected.
Understand. Great. Wonderful. All right. That will be that. So is it correct to assume that the next meeting would be 2 weeks from today?
Yes, the next one would be on the 20th.
Right, great. And I did ask Director Figueroa about the re-election of the committee. I got the impression from city staff that actually June 30th is the end of a term, but it appears that I'm still the chair right now. So would Mr. Figueroa or staff would have some input for us so that the committee can be prepared? Thank you.
Thank you, Mr. Chair. I will be coordinating with the city clerk on both the reorganization of DRC and Planning Commission. So if it does not happen on the next meeting, I anticipate that it would happen on the first meeting of August. As soon as I have word from the city clerk, I will communicate that to the chair and the vice chair to prepare the committee.
Thank you, Director Figueroa, for the update. Appreciate that. Any other committee member may have any other questions or issues to share, bring up? Going once, going twice, I see none. So I would say today's meeting is successfully completed, and I will call to adjourn the meeting today. Thank you very much, and see you in 2 weeks' time, if not sooner, in person.
Thank you.
Thank you, Pete.
Take care. Have a good
you.
evening.
Good night,
Goodbye.
everyone.
Bye.
Good
Good
night.
night.
And for the sake of the meeting minutes, I am just stating for the minutes that the meeting has adjourned at 7:44 p.m.